Well, good afternoon, everyone. My name is Jessica Diaz, and I am here with my colleagues Nick Aquino and Tenzila Huda, and we are with the Los Angeles County Department of Consumer and Business Affairs. Joining us today is Kelsey Atkinson with Legal Aid Foundation of Los Angeles, and shortly we'll be joined by Lori Blevins with Housing is Key. I apologize for the mask. I am in the office, so I'm just going to have to be pushing it up and down every now and then. For today's presentation, we will cover what is COVID-19 rental debt, how rental assistance can help, the process of small claims court, and using mediation as an alternative to going to court. At the conclusion of the presentation, we will be answering your questions during the question and answer session. Tenny, do you mind going on to the next slides, please? Thank you so much. Please note that your microphone is currently on mute. You may ask questions at any time during or after the presentation by submitting them through the chat box located on the lower right of the WebEx interface page. It is a good idea to leave the chat box open, even if you don't ask questions, because you will be able to view valuable information entered in the chat during the course of this virtual forum. This virtual forum is being recorded and will be available on our website along with other resources. Just go to dcba.lacounty.gov. At the conclusion of today's presentation, we would appreciate you completing a short survey to let us know how we are doing and give us suggestions for additional webinars. All feedback is welcome. And now I'll hand it off to Kelsey.
Great. Thank you for that introduction, Jessica. Teddy, can we skip forward a couple slides to the, let's see, that slide. Thank you. Okay, so I'm going to be talking about what is COVID-19 rental debt. My name is Kelsey Atkinson, and I am a staff attorney for the Renter Small Claims Project with the Legal Aid Foundation of Los Angeles. Next slide, please. So first and foremost, if you have received an eviction notice, please contact Stay Housed LA, either at stayhousedla.org or by phone 1-888-694-0040. We will not be covering eviction protections and eviction processes during the COVID-19 pandemic in this presentation. So please contact Stay Housed LA to get connected to assistance through the information on the slide. Next slide. So what is COVID-19 rental debt? Throughout the pandemic, tenants impacted by COVID-19 could not be evicted for failure to pay rent if from March 1st, 2020 to August 31st, 2020, they submitted a declaration of COVID-19 related hardship, and that could be submitted retroactively, and only one declaration was required during that time period. Then, from September 1st, 2020 to September 30th, 2021, tenants needed to submit a monthly declaration of COVID-19 related hardship to their landlord. So these protections ended on September 30th, 2021. Next slide. So from now on, to avoid eviction, tenants need to first ensure that they've paid 25% of rent from the period from September 1st, 2020 to September 30th, 2021, and they need to pay rent in full from October 2021 onwards. And we'll talk about this more in the presentation, but you can apply for and receive rental assistance to cover up to 18 months of these rental payments, including to cover that 25% rent that needs to be paid from September 2020 to September 2021. Next slide. So tenants still must pay back the remaining rent they could not pay during the pandemic. So even though tenants may be able to avoid being evicted for the rent they accrued, and they hopefully will apply for and be able to receive rental assistance to cover some or all of it, some tenants may be in a situation where they will need to pay back some remaining rental debt that they accrued during this March 2020 to September 30th, 2021 period. So this is called COVID-19 rental debt. And this rental debt is considered a consumer debt. Next slide, please. So how much COVID-19 rental debt a tenant owes can depend on if they've received rental assistance. State law guarantees that qualifying households will have 100% of their COVID-19 rental debt covered for up to 18 months of assistance. And landlords or tenants can start an application for rental assistance via Housing is Key. And we have folks here with us today from Housing is Key who will talk more about the application process in detail. Next slide. So if a tenant does not or cannot pay their COVID-19 rental debt, so again, they've met the 25% threshold from September 2020 to September 2021, and they're current on their rent going forward, their landlord can sue them for any remaining rental debt starting November 1st, 2021. Landlords can sue for this in small claims court or general civil court. And I want to be clear that these lawsuits are not an eviction. A tenant cannot be locked out of their home when they are given these lawsuit papers. And if they lose this case ultimately in court, they cannot be evicted. Next slide. So in order for landlords to sue for COVID-19 rental debt, they actually have to show that they've made a good faith effort to investigate what rental assistance is available for the tenant, cooperate with the tenant's efforts to obtain rental assistance, or sought rental assistance for the tenant. So again, it's important for landlords to also know about how to access rental assistance, which is why we have Housing is Key here with us today. Next slide. And a few other additional rules that apply to COVID-19 rental debt. Landlords may not charge late fees or interest on rent from March 1st, 2020 to September 30th, 2021. If the tenant is still living in the unit, a landlord cannot apply the security deposit to the rental debt without the tenant's written permission. And COVID-19 rental debt may not be sold or assigned in certain cases. So there are restrictions on selling that debt to debt collection agencies and other types of companies. Next slide. So that's it for me, and I will hand it over to our colleagues at Housing is Key to talk more about how rental assistance can help tenants reduce the rental debt that they may owe.
Good morning, everybody. Thank you for being here and thank you for the presentation. My name is Lori Blevins, and I am the section chief or a section chief at HCD for the Emergency Rental Assistance Program. Slide. Next slide. So the program started, was launched on March 15th, 2021. We were given about 15 days to launch the program from the time we signed the contracts with the U.S. Treasury. So the program was really set up very, very fast, and which is amazing when you think about the amount of applications that we have processed and the amount of funding that we have funded to date. The program focuses on stabilizing low-income households through the payment of rental arrearages to landlords and to the tenants. We also have 135 organizations in our local partner network with boots on the ground to assist people in their communities, help them apply for assistance, and help them find other available assistance in their community. As of October 19th, we are close to $900 million in rental assistance paid, including utilities, and we have assisted over 75,000 households throughout the state of California. Next slide. The process, the parameters for applying is that the landlord and tenant applicants will be compensated for 100% of the rents. Unpaid rents accrued from April 1st, 2020 for a maximum of 18 months. We will also pay current and prospectives in 3 months increments going forward, and past due utilities. Non-occupancy payments are also allowed. It allows the rental assistance to be paid in situations where the tenant has already vacated the property but still owes the arrearages. And the payments generally go to the landlord if the landlord is participating. However, if the landlord does not participate, we will send the funding to the tenant, and it is required that the tenant forward that funding or those payments to the landlord within 15 days or face penalties. Okay. So the eligibility criteria is income-based. The income must be at or below 80% of the AMI for the county in which the property is located. The tenant must be at risk of experiencing homelessness or housing instability, experiencing a financial hardship due indirectly or directly to COVID-19, and no proof of citizenship or immigration status is required. Prioritization, however, is given to those that are at most risk of eviction and at risk of impacted by COVID-19. Eligible uses, as I said, were rental arrears, prospective rents, utility arrears, and other household-related services, including internet as one of those. Next one. Next slide. So this is the landing page of Housing is Key. Actually, it has been updated a little bit since this screenshot was taken, but it's not much different. You can see that we have our applications in 6 languages, including English. So this is where you start to apply. Go to Housing is a Key, apply now. Or if you have an application in process, you can also start here to find the status of your application. So once you apply now, next step. Next screen. Once you hit the apply now, you're directed to this page, which will help us determine, and you determine, what program is assisting you in your area. The state of California does not administer every locality in the state. The Treasury provided direct funding to larger localities across the state. So there are some that are still administering their own program. The city of LA, county of LA is in the state program. However, Placer County, for example, is running their own program. So when you start here, you enter the property address, and this will send you to the appropriate program website where you can apply for assistance, basically. We call it the no wrong door. So regardless of whether or not you live in an area where the state is running the program or there is a local program, this will get you to the right program. Next slide, please. So what do you need to apply? So if you're a renter, we do need to verify income because we do have an obligation as required by the funding for 80% or lower median income. So these are just a few of the documents that you can submit if you're a renter to document your income. 2020 tax return, a 2020 W-2, 1099, pay stubs, or proof of participation in any other state or federal subsidy programs such as CalFresh or CalWorks. If you are applying for help with utility bills, we do need a copy of the utility invoice or statement for unpaid utility, water, trash, and internet bills after April 1st, 2020. The landlord needs to also apply, and what we need from the landlord is a copy of the lease or the rental agreement, something that establishes a relationship between the property and the tenant. We also need to see some type of a rent ledger that will identify the amount of rent owed and for what months, because we only provide assistance from April to 2020 forward. So that's important. But I want to just stress that it doesn't have to be super fancy. It doesn't have to be an exact rental agreement. We understand that some of our landlords are smaller landlords and they've had the tenants for years and years, so they may not even know where the current rental agreement is. So we're very flexible on what types of documentations the landlord can supply. But we do require a W-9 for the landlord, and if the landlord does not want to provide us a W-9, then we would just consider it the landlord not participating, and we would consider a renter-only application. I do want to stress how important it is for the application to be as complete as possible. When you apply, that helps streamline the process, because if we have to reach out to the landlord and or to the renter for additional information, it does delay the process. Next slide, please. So this is just a visual of what is required, because the landlord initiates a separate application from the tenant. It's very helpful if the landlord can provide us with the tenant application ID number and vice versa. That way we can match the tenant and landlord application from the start. Otherwise, it's somewhat of a manual process. And as I said before, if the landlord does not participate, then we will continue with the application process of just the tenant only. We are required to reach out to the landlord, and I think we reach out to him 3 or 4 times over a 5-day period to get the documentation that we require from the landlord in order for the landlord to participate. If we don't hear back from that landlord, then we switch it to a tenant-only application and we will proceed. So our application process has been simplified since we opened up the program. Obviously, there was a lot of things that we didn't think of. We only had 11 days to do it. So we have simplified the process as much as we can think of, really. I mean, we update it almost every day, actually, to tell you the truth. But we have seen a tremendous upticks in applications submitted and in calls to our call center since the October 1 eviction changes. So we have almost 350, close to 400,000 applications in the system that we are currently processing. But the application process does take less time to complete and is quicker to review. But again, you know, a completed application is the best way to get this application through the pipeline. Our website is translated into 6 languages, including English. And I think our application or our website is easier to navigate. We just made some recent changes to it, updated it for self-service portal, where the applicant and or the landlord can start at the website and provide and get a documentation that they would need for the courts to verify participation in the program. Next slide. How is the state communicating with landlords and tenants? So there's a lot of ways that we communicate. You know, we do have a statewide communication advertising program, both print media, we have commercials, we have radio ads, we have print ads. We also work with our local partners, our LPNs, our local partners in our network across the state. This is managed by LISC, a national CDFI with a large California presence. We have over 100 organizations with option A and I should say option B jurisdictions. We have ground effort via paid and unpaid partnerships to increase awareness of the program and support access to the program. The local partner network will help an individual or family actually apply for assistance, and they can also make themselves a representative of that applicant, so they would receive notifications as that application proceeds through the system. We've also partnered with United Ways 211 that has a multi-language information, and if you text rent, it will provide you with the information for the state for basic program information. Next slide, please. So new landlord obligations effective October 1 through March 31st, 2022 as part of AB 832. Next slide. So I'm going to talk a little bit about what happened or what changed after September 30th. So the AB 832 actually extended tenant protections of the provisions for AB 3088 and SB 91 until September 30th, 21. So effective October 1st and until March 31st, there is a modified process for unlawful detainers that the landlords must follow. And then AB 832 also updated and expanded the state's emergency rental assistance program, additional funding, and expanded the amount of rent that we could pay. Next slide. So the temporary court process that I mentioned that the landlords must follow, effective October 30th, a modified procedure is in effect until March 31st, 2022. The key components of it is that it ends the state's eviction protections. It returns to a 3-day pay or quit notice, but it does require the landlord to apply for rental assistance prior to proceeding with an unlawful detainer. So ending the state's eviction protections, the tenants can no longer submit a declaration of COVID-19 related financial distress in lieu of paying rent. I think that was mentioned in the previous presentation. Tenants who did not pay 25% of their total rent due between September 1, 2020 and the end of September 2021 can be evicted for failure to pay their rent. And most pre-AB 3888 eviction laws go back into effect. Next slide. So here's a quick reference for our program. We have the call center, which is where the processing center processes all of the applications. So that is the number if you want to call for information about your application, or if you have questions about, if you're a court representative of the court, you can call there and get documentation supporting that the applicant has and or landlord has applied for assistance. The phone number for our local partner appointment center and another call center where you can call in to actually apply for assistance. We call it our application call center. There is the link to look up where in your area is the UAP program for your area. Again, as I mentioned, not all localities are participating in the state program. Some are running their own. That will get you to where you need to be. We have our dashboard, which includes the data for the all of the localities that the state is running. You can search through this dashboard based on locality to see what has, what kind of assistance has been provided, what has been requested, both in rental assistance and in utilities. And again, that's only for the localities that are participating in the state program. And then again, a local partner organization lookup. You can go to that link and find what LPN is available in your area. Next slide. So that's the end of my presentation. I will take any questions or comments.
Lori, what we're going to do is we'll have a Q&A session because we have a lot of questions that are coming in, which is great.
Okay.
But we'll wait towards the end of the presentation.
Okay, that's perfect. Thank you.
Thank you.
Good afternoon. My name is Nick Aquino. I'm the small claims supervisor, and together with Kelsey, we put together some information that I think is important for you to be aware of in either utilizing small claims court as a landlord to sue for the back rent, or as a tenant considering possible affirmative or defenses you can raise at the time of your hearing. Next slide, please, Jessica. Okay, so starting November 1st, renters can be sued in small claims court for any amount, even if it exceeds $10,000 for unpaid COVID rental debt. Now, I also want to point out that the stipulation that you can only file 2 cases for more than $2,500 in any calendar year has also been waived, which means that landlords can sue, I don't know, as many times as they would need to for an amount over $10,000 in small claims court. It does provide, I believe, an easier road to follow for landlords, and I think it's also easier for tenants. Next slide, please, Jessica. So forms. The administrative office of the court has developed, with input from stakeholders, a couple new forms that are going to be utilized. The SC 500 is designed exclusively for lawsuits involving COVID-related rental debt. The 500A is if you have to list more than one defendant, you would use the SC 500A, again, exclusively for COVID rental debt cases. The SC 500 info is I think it's like a 3-page sheet that kind of explains the nuances and changes that may exist with regards to the COVID rental debt cases in small claims court. A couple other forms have been revised with either disclosures or disclaimers concerning the COVID-related rental debt. So those are kind of the new forms, revised forms that my staff here at Department of Consumer and Business Affairs will be more than happy to walk you through and help you out with. Next slide, please, Jessica. I included a slide on service because serving court papers can get a little tricky at times. Litigants cannot serve these forms themselves. They must be served either by the sheriff or a registered process server or a friend or family member that's not involved in the lawsuit. And there are actually two types of service: personal service, where the paperwork is given directly to the party being sued, and substitute service, where the paperwork is left possibly at the home where the defendant resides, and another copy is mailed to that same location. There are also time periods involved for both methods of service. And the final time period is that at least 5 days prior to the court date, proof of the paperwork being served must be filed with the court. If you hire a registered process server or the sheriff, that step is taken care of for you automatically. I'd also like to point out, in small claims court, you used to be able to serve via certified mail through the court clerk. That option no longer exists in LA County. Hasn't existed for about the last 4 years. Next slide, please. The court is kind of stepped it up, and they realize how important it is to make access as easy as possible. With that being said, through LA Court Connect, you will be able to actually remotely appear for your court hearing, either virtually through the internet or telephonically over the phone. And this service is provided free of charge. So it allows, court appearances from your home, the office, for that matter, almost anywhere. Next slide, please, Jessica. Exchange and submission of evidence has also changed. And the court is requiring both parties, if they are going to submit evidence, it needs to be submitted to the court at least 10 days prior to the hearing. And there are two forms that are used. The first one, LASC CIV 278, is actually the form itself that needs to accompany the evidence. And LASC CIV 279 are mailing labels that you should be utilizing on the envelopes where you're mailing the evidence. A couple other points regarding this. The evidence not only has to be submitted to the court, you need to ensure a copy of the evidence. Don't need the form, but of the evidence is mailed to the other parties involved in the case. We usually recommend, it's a good idea to go to the post office and get a proof of mailing receipt. Cost, I don't know, about $1. Not a certified mail, but just a proof of mailing in case there is an allegation that the evidence was not mailed to the other party. The other recommendation, strong recommendation, is you should be submitting copies to the court. If you submit originals, you will be required to include an envelope self-addressed with appropriate postage to have your evidence mailed back to you. Next slide, Jessica, please. ODR is an online method to try and resolve the small claims court dispute prior to actually going to court. It is required that parties register within 5 calendar days of receipt of the notice. And we have numerous short vignettes to walk you through the entire process to help you out in utilizing this service. Next slide, please. This is a copy of the Department of Consumer and Business Affairs homepage for small claims. And I'd like to point out the boxes that exist and information. In particular, we have sample forms of all the sample forms that are utilized in small claims court to guide you in filling them out. We have a huge amount of videos and webinars on a variety of small claims court topic matters. And I would strongly recommend that anybody considering going to small claims court, or for that matter, who's been sued in small claims court, take a look at the main video that we have posted on our website, as it provides an excellent overview of the entire small claims court process. Next slide, Jessica.
And I also wanted to let folks know that in particular for COVID rental debt suits brought in small claims court, LAFLA will be hosting workshops to assist tenants who have been sued in these cases. We will be providing assistance with reviewing the small claims court documents that you receive, as well as assistance in preparing for the small claims court hearing, including discussing defenses that you can raise with the judge. So you must represent yourself in the small claims court hearing. That said, you can still talk to a lawyer about your case before you go into the hearing. So for more information on these workshops, you can visit lafla.org /COVID resources /renter small claims, or you can call LAFLA's main line 800-399-4529 and get connected with some additional assistance and information about your specific situation. Next slide.
Hello, my name is Tanzila Huda. I'm a mediator at the LA County Department of Consumer and Business Affairs Dispute Resolution Program. And today I'm going to talk about mediation and why it is an excellent alternative to litigation of COVID-19 debt. Next slide, please. Next slide. Okay, so I'm going to skip this slide because I think we'll run out of time. So let's go to the next slide, please. Okay, so what is mediation? Mediation is a confidential dialogue-based process where a mediator assists 2 or more parties in resolving their disagreements. The participation by both parties must be voluntary. The goal is to find a mutually acceptable solution to the problem or the disagreement. So in its simplest form, mediation is a conversation, but it's a guided conversation, and it's guided by the mediator. Next slide, please. So what is the role of mediators in the mediation process? Mediators are third parties, which means that they are not directly involved in the dispute itself. They are neutral, which means they have no stake in the outcome. They're impartial, which means they will not be swayed by favoritism, bias, or prejudice. They will treat both parties fairly and will not favor one party over another. They will provide equal opportunities to both sides to tell their stories, be heard, ask questions, and express their desires and concerns. Mediators are trained in communicating effectively and diffusing emotionally charged situations because you need someone who is not emotionally involved in the fight to be in the room to prevent the conversation from getting out of control. Mediators are also messengers and storytellers. They carry information, offers, counteroffers, questions, and answers between the parties. They help the parties say what they were not able to say to each other. They assist the parties in the problem-solving process by encouraging them to brainstorm and evaluate all their available options. Mediators do not give legal advice, they do not share their personal opinions, and they do not tell the parties what to do. Next slide, please. Yes. So here we have a chart that illustrates some of the differences between mediation and litigation. I'll just go through some of it. So a very big reason people prefer mediation to litigation is the confidential and private nature of the mediation process. It shields you from sharing personal details of your life with strangers or in open court. Litigation, on the other hand, is a public process. Mediation is a collaboration requiring the parties to cooperate and share information. Litigation is an adversarial process that fosters hostility. DCPA mediation services are completely free of charge, but if you decide to sue, you will end up spending money on court fees, attorney fees, travel expenses, etc. You can participate in our mediation program from the comfort and privacy of your home. Our DCBA mediation program uses, for communication, we use emails, phone calls, online portal messaging, and also video conferencing to facilitate all the communications between the mediators and the clients. You may get faster resolution through mediation. Sometimes all it takes is a series of phone calls, like short phone calls or emails, to resolve the dispute. Mediation is an informal process, free from the rigid rules of litigation. The informality allows the parties to be more flexible and creative in the problem-solving process. We humans are complex beings, and money is not the only thing that can satisfy our needs. Sometimes an apology letter or an opportunity to clear up misunderstanding resolves the conflict. People tend to find mediation to be more emotionally satisfying than the litigation process. The mediator provides a safe space for you to tell your side of the story and vent your frustrations. Storytelling, talking about yourself, is what makes us human. Stories humanizes your opponents and helps you relate to each other. You also get the satisfaction of knowing that the other person is finally listening to what you have to say. The most important difference between mediation and litigation is that in mediation, you are in the driver's seat. You decide the outcome and you control the results. Whereas in litigation, a judge or jury will decide your fate. Next slide, please. So how mediation can help landlords and tenants resolve COVID-19 debt. So I urge you to give mediation a try before resorting to litigation. Allow a mediator to help you communicate with each other and work out a payment plan or a settlement. Mediators are trained negotiating with both sides, so let the professionals do the work for you. If you are a tenant, resolving the dispute through a mediated debt settlement plan will help you avoid getting sued in the future. If you are a landlord, mediation will help you resolve the debts faster than suing your tenants in court. But suppose you have already filed a lawsuit or have been sued, well, no problem, because DCBA mediates thousands of litigated cases and helps parties reach out-of-court settlements. We will draft the legally enforceable court-stipulated settlements for you, and we will have the lawsuit dismissed before the trial. We will also go to court and file it for you. Next slide, please. So how to request mediation? We accept online mediation requests. All you have to do is submit an application, go to dcba.lacounty.gov, click mediation, and then click online mediation request form. And please note, you either the landlord or the tenant, either one of you could request mediation. Next slide, please. We need the following information in your mediation application. We need your full name and the other party's full name, your address, the other party's address, your phone number, and the other party's phone number, your email address, and the other party's email address if you have it. A brief description of the dispute is needed, such as, I'm a landlord and my tenant owes me X dollars in COVID-19 debt, or I'm a tenant and I owe X dollars in COVID-19 debt. We want you to provide a brief statement of your desired resolution. And we prefer that you propose a solution in your desired resolution. For example, if you're a landlord, you can state, I'm willing to give my tenant 5 months to pay off the debt, but after that, I'm going to court. Or if you're a tenant, you could write, I would like to pay off the debt in 10 monthly installments, but I need my landlord to promise me that he will not sue me during that time. If a lawsuit has been filed, the application form will ask you about it. So say yes, and then you have to give the lawsuit number and the trial date. Now I would like to give you a few tips about your mediation application. A mediation request is an invitation because participation is voluntary. Now you want your request, you want your invitation to be accepted by the other party. So please don't write anything that will make them turn down the invitation. So focus on your goal, which is to solve the problem. When you're writing your request, focus on the goal. Don't use the application form to vent against the other side. Don't demonize, denigrate, or shame them. It will only antagonize them, and they may end up saying, you know what, I don't want to mediate with this person. Focus on the future and not what happened in the past. Propose a solution to the problem and express your willingness to cooperate or even compromise to bring the matter to a close. Next slide, please. So one of the principles of mediation is party empowerment or party self-determination, because we believe no one knows your situation or your life better than you do. However, no matter how well you know your life, you may not know or understand all the current COVID-19 rules and regulations. That's why we strongly encourage you to please speak to a housing specialist to find out your rights and responsibilities. Mediators cannot give legal advice or tell you what to do. That is why it's really important that you speak to an expert, like the people on the panel today, to find out, to make a more informed decision. You may consult the housing specialist before seeking mediation or at the same time. It will take about 10 or 15 minutes, and you can call anytime Monday through Friday between 8 a.m. and 4:30. The numbers are on this slide. So that's all I have for you, and thank you for listening.
Thank you so much to all of the panelists for the great presentations. I think we have had a lot of information that was shared to the public today, which is great. We have a ton of questions that we've been receiving to the public. So quick disclaimer to the folks that are attending the presentation. If I don't get to your question, because we do have a lot of questions and we only have about 15 minutes, please send us, we're gonna drop on the chat the link where you can submit a question and answer to our department. So that way you have those resources available should we not get to your question. Okay, let's begin. One of the main questions that has been coming up a lot is there's a lot of different extensions on eviction moratoriums. So I would like to see if the panelists can please turn on your cameras if you're able to, so that we can get some of these questions answered. Have the Board of Supervisors, they've assumed, the public has assumed that the Board of Supervisors has extended the eviction moratorium until February 2022. Is that an accurate statement, or can we go through possibly the breakdown of those eviction moratoriums?
Jessica, let me try and address a very complex motion that was approved by the board. In certain circumstances, the answer would be yes. I would strongly recommend that anybody who has questions concerning that to give us a call or pose a question in the chat that can be handled by one of our rent stabilization housing specialists to make sure that they get accurate and complete information.
Okay, great. The other question, the information that was shared today, does this information only apply to residents or to commercial businesses as well?
In terms of my portion of the presentation regarding the COVID-19 rental debt, that is with respect to residential tenants and not business tenants, but I don't want to speak for the other presenters.
Concerning small claims court, it applies to both with regards to the limits, the amounts, etc., in the forms.
And the state CRAP program is residential only.
Thank you so much. And for mediation, we do accept mediation requests from both businesses and tenants for residential properties. Okay, another question is, what if I as a landlord have applied, but my tenant has not paid and is refusing to fill out the forms?
So I will take this call. If the tenant, once the landlord applies, then the tenant has 15 days to apply. If not, then the landlord can proceed with unlawful detainer.
Great, thank you. And then there's another question is, can I begin small claim suit if my property is located in the city of Los Angeles?
So small claim suits can begin November 1st, 2021. And as Nick mentioned, there are specific forms for that if it is for COVID-19 rental debt. So that is the SC 500 form. The importance of that form is that it instructs the clerk to mask the filing so that only certain people can have access to the court records and information, as opposed to it being a typical public court filing. The other thing I would point out, and this addresses another question I saw pop up in the chat. So there is under the LA City, City of LA ordinance, a little confusion. So the ordinance does say that landlords cannot evict within the protected period, and that rental debt is not due for 12 months until after the mayor declares the end of the emergency period. That said, the law kind of has a hole in it basically, and that it doesn't prevent a landlord from filing on November 1st to recover rental debt, since that's a civil action distinct from an eviction. And so I do believe that tenants will be able to use this City of LA ordinance as a defense, but I think unfortunately the ordinance does not stop the landlords from being able to file.
Okay, great. Thank you so much, Kelsey. Another question is, and I believe this one's going to be specifically for Lori for Housing is Key. If a renter or landlord does not have contact information, for example, email address, phone number for their renter or landlord, what is the process in which Housing is Key is contacting each party to continue with the application review process?
That's a really good question. So when a landlord applies for assistance, if they don't have the tenant contact information, we send it regardless. We send a hard copy letter by U.S. mail to the property address, advising the occupant of that property address that their landlord has applied for assistance, and that they have 15 days from the date that the landlord applied to apply for assistance. If a tenant applies and they do not have contact information, or maybe not even good contact information, We make 3 attempts over a 5-day period to contact that landlord. After the 3 attempts, 5 days, if we're not able to get in contact with the landlord, we switch that application to a tenant-only application, and the benefits are sent directly to the tenant, and the tenant has 15 days to pay the landlord.
Okay, great. And then perhaps maybe you can help us with this next question as well, Lori. What if I, as a landlord, have applied, but my tenant has not paid and is refusing to fill out the forms?
That's pretty much the same question. I know that the city and county have moratoriums, but as per AB 832, if the landlord applies, which is required, they need to show the courts that they have applied for assistance, and the landlord or the tenant, I'm sorry, has refused to apply or is not cooperating, then the landlord can proceed with eviction. They do need to wait 15 days, and they do need to do some attestations to the court.
Thank you. And then there's a question, there's a few questions, and I'm going to try to summarize this one regarding rental freezes. Is there still in effect any rental freezes?
I'm gonna let LA, or the folks from the LA city and county speak to that.
And if we don't, it's okay if our panelists currently don't have that answer. What we could do is we can definitely also drop the link on the chat for our phone number to speak to our counselors over at our rent stabilization unit as well. But Kelsey, do you have any information on that?
I don't have any information on that directly on hand, especially because that can vary a lot depending on where you live and various other factors. So, in order to avoid talking about it for the next 10 minutes, I think that's if there are specific questions, it's best to contact someone at DCBA, or Stay Housed LA is also a great resource on that as well.
Sure, thank you. And we have dropped the contact information to speak to one of our counselors over for your rights and responsibilities regarding that. If you open up your chat, you should be able to see that phone number. A question regarding the status of the application. So how can one see the status of the application to get proof for court?
So you can access it through our website. So you could go to Housing and Key, and there's a button that says apply now or check status of your application. So you check that you click that button, it'll take you into eventually into the portal that you would log into using your login information, including a password. And then there is a button there that says get application status. You click on that button. Actually, it's not a button, it's a link. And a letter comes up that is what is required by the courts to verify participation in the program. You can either print it or you can send it to your phone, or however you want to do it, and that would be what you would take to court. That's available for both the tenant and the landlord. Now, if you're a court participant and you're wanting to verify application, then you need to call the call center. We have an IVR system set up so the courts go directly to a customer service rep and are answered immediately.
Okay, great, thank you. And then a few individuals were also asking regarding the presentation, if they can have copies of the slide or if they can share the information as resources. So this virtual forum is being recorded and is going to be available on our DCBA website. So once the conclusion of the presentation has concluded, then we'll be able to share that link over to our website, and you're more than welcome to use the recording as needed. And then Kelsey, I'm not sure if you might be able to answer this question, but someone was asking if they can receive MCLE credit.
Not for this presentation, no.
Okay. Thank you.
That said, if you are interested, we have created a series of trainings, LAFLA in conjunction with the Pro Bono Training Institute. And there's a series of 3 trainings on COVID-19 rental debt and the small claims court process available on PBTI, where you can get CLE credit.
Thank you. And now we have just about 5 more minutes. We can get through just a few more questions. One of the questions that also came in is, can late fees begin to be charged beginning October 1st?
For the state program, yes, and we will actually cover late fees beginning October 1st.
That is a good question in the sense I know under the state law that ends as of September 30th, but I'm thinking through that now and I want to double check the city and county moratoriums on that.
Okay. And then a question for mediation. Is there translation for mediation specifically for Korean speakers, or do we have any other available languages offered for mediation?
Yeah, if you let us know in advance, we do get other language requests, and we can request translation services. So the answer is yes. Just let us know in advance, and you can put that in your application.
Sounds good, thank you. And then one more question. I believe we have time for maybe just one or two more questions. How long does it typically take for the funds to be dispersed?
So the state program, it depends. If you have a complete application and you are very good about, submitting everything the first time around, the application goes through a lot quicker. We strive for 30 days, but we're really not there, to be perfectly honest. We have over almost 400 applications in the pipeline. So right now, with a completely perfect application, I would say probably 5 to 6 weeks. And if there is additional information that is needed, then that delays it because you just kind of stop in a process, and there is an email that goes out to either the landlord or the tenant requesting the information. So then it becomes very important that the landlord and or the tenant is very responsive to whatever that request for additional documentation is. So, it can take up to 2 months depending on how responsive the landlord and the tenant is, and up to 6 weeks if everybody is very responsive.
Awesome, great, thank you. And then I believe we have time for one more question. This one might be for mediation. Is the mediation service available for residents and landlords in any of the cities located in Los Angeles County?
Yes, it's available to anybody as long as one of the parties is a resident of LA County.
Tenzila, I believe we lost your audio.
Oh,
I can hear.
can you hear me now?
Yeah.
Yeah.
Okay, sorry about that. Yeah, so we just need one of the parties to be a resident of Los Angeles County. So any of the cities in Los Angeles County, yes.
Okay, sounds good. Now, just really quickly, just a little reminder, I know we have a lot of questions still on the chat that were not answered, so our apologies, but the time that we do have is just about 1 more minute left. What we'll do is we'll drop again the information for our contact information, and then we'll go over to the next slide, so that way you also have additional contact information for the departments that were here today.
Thank you, Jessica.
Thank you, everyone.
Appreciate it.
No, thank you, everyone. Does anybody have any final thoughts?
Thank you for attending, everybody.
Thank you.
Thank you, everyone.